Thank you, Honourable Senators. I rise today to speak against Senator Harder's amendment and in favour of Senator Smith's motion authorizing the Senate Legal and Constitutional Affairs Committee to investigate allegations of PMO interference with the former Attorney General, MP Jody Wilson-Raybould, regarding the criminal prosecution of SNC Lavalin. These shocking allegations strike at the very heart of our criminal justice system. I served as the Chief of Staff to the Saskatchewan Minister of Justice for almost 5 years, and I can tell you that the independence of the Attorney General is Chapter 1 in any AG's briefing book. It's as basic and fundamental as it gets. Like all Canadians, senators want answers in this matter. We are rightfully concerned about this potential subversion of the rule of law and the independence of our justice system. My Conservative caucus colleague, MP and justice critic Lisa Raitt, recently asked the members of the House of Commons who are or have been lawyers to remember the oath they took upon being admitted to the bar. I shall champion the rule of law. As a lawyer, I make that same appeal to all my Senate colleagues who have sworn that oath. It is incumbent upon us to vote to uphold this key principle underpinning that oath. In recent days, the Prime Minister's office has tried to spin the narrative that pressure on the Attorney General was a normal part of the decision-making process, but that they never put undue or inappropriate pressure on Minister Wilson-Raybould. Honourable Senators, Jody Wilson-Raybould was the Attorney General of Canada. Anything that rose to the level of pressure on her to take a particular action on a criminal prosecution was undue and inappropriate, especially after the Director of Public Prosecutions had already ruled and Wilson-Raybould had already told the Prime Minister that she had no intention of reversing that decision. What was undue and inappropriate was the Prime Minister, his most senior staff, Gerry Butts and Katie Telford, and Clerk of the Privy Council, Michael Warnick, refusing time and again to take the Attorney General's no for an answer for 4 months after the decision was made. What was inappropriate was Trudeau and his office trying to badger the Attorney General, to wear her down, to try to get the result they wanted, and when they didn't get it, they removed her as Attorney General. What we know already from the testimony on record is that something extremely disturbing happened here. The Director of Public Prosecutions ruled on September 4, 2018, that SNC Lavalin would not receive a deferred prosecution agreement and that these criminal charges would proceed to trial. On September 17th, Prime Minister Justin Trudeau and Privy Council Office Clerk Michael Warnick met with Attorney General Jody Wilson-Raybould. Wilson-Raybould informed the Prime Minister that she would not intervene in the DPP's decision regarding SNC Lavalin. Wilson-Raybould testified that Prime Minister Trudeau pressed her to consider the electoral consequences of SNC failing. He spoke of the upcoming election in Quebec and said, quote, "I am an MP in Quebec, the member for Papineau." Wilson-Raybould was alarmed, and she said, quote, "My response, and I remember this vividly, was to ask the PM a direct question while looking him in the eye. I asked, 'Are you politically interfering with my role, my decision as the AG? I would strongly advise against it,' quote. And did the PM then back off? No. Warnick met with SNC Lavalin and instructed them to pursue the matter with Wilson-Raybould. On December 5th, Trudeau's right-hand man, Gerry Butts, and Minister Wilson-Raybould met at the Chateau Laurier Lounge and discussed the matter of SNC Lavalin, where Butts again pressed her about needing an SNC solution. Keep in mind, of course, that at the very first Liberal government caucus meeting in 2015, Prime Minister Trudeau told his Liberal MPs that any communication coming from Gerry Butts was to be considered as coming from him. The day following that conversation, December 6th, Prime Minister Trudeau wrote to Wilson-Raybould, passing on SNC Lavalin's letter asking for reconsideration of a deferred prosecution agreement. On December 18th, the Prime Minister's top 2 staffers, Gerry Butts and Katie Telford, met with Minister Wilson-Raybould's Chief of Staff, Jessica Prince. They tried to press Prince in what Wilson-Raybould called the, quote, "final escalation in efforts by the PMO to interfere in this matter," quote. Prince was upset by the conversation and recounted it to Wilson-Raybould via text message. She quoted Gerry Butts as saying, quote, "Gerry said, 'Jess, there is no solution here that doesn't involve some interference,' quote. Katie Telford said, quote, 'We don't want to debate legalities anymore,' quote. The next day, December 19th, the PCO clerk, Michael Warnick, had lunch with the Prime Minister and senior staff. That afternoon, Wernick called Wilson-Raybould to, as he put it, check in on the SNC Lavalin matter and convey context that the Prime Minister and the Minister's cabinet colleagues were anxious about the economic consequences of SNC Lavalin's criminal prosecution. Jody Wilson-Raybould experienced it differently. She quoted Wernick as saying, quote, "I think he, Prime Minister Trudeau, is going to find a way to get it done one way or another. So he is in that kind of mood, and I wanted you to be aware of that," quote. The veiled threat was clear: reverse the DPP's decision or lose your job. How many times did Jody Wilson-Raybould have to say no to these men in power? They kept pushing and pushing, trying to wear her down. Even in the face of this unrelenting pressure, the Attorney General refused to overturn the DPP's decision to prosecute SNC Lavalin. About 2 weeks later, she was told she would be shuffled from her position as Minister of Justice and Attorney General and into the portfolio of Veterans Affairs. Some senators have said that they are planning to vote against Senator Smith's motion, claiming that the House of Commons Justice Committee is the best place for this investigation. However, at times that Liberal-dominated committee has demonstrated that it is not interested in uncovering the truth here. The Liberal majority initially voted to exclude witnesses from the Prime Minister's office, including Jerry Butts, who are directly implicated in these allegations. When he resigned, Butts completely denied that he had anything to do with pressuring the Attorney General. The record seems to suggest something else entirely. But the question remains, why did Jerry Butts resign if he didn't do anything wrong? His denials must be tested for veracity. Instead of hearing from certain witnesses directly involved in the events at hand, the Justice Committee opted to hear from academics and civil servants about the theoretical application of procedure and laws. It's curious how the Trudeau government members are now so interested in learning about the Shawcross doctrine of prosecutorial independence. By the end of this scandal, there might be a few Liberals looking for a Shawshank redemption. The Liberal-dominated House Committee begrudgingly agreed to let former Minister Wilson-Raybould testify, but she remained bound by certain key aspects of solicitor-client privilege during her testimony. The Senate Legal and Constitutional Affairs Committee is in a position to hold much more comprehensive hearings into this matter. Furthermore, this study would directly relate to previous legal committee business. Last spring, our legal committee studied the inclusion of remediation agreements, or deferred prosecution agreements, DPAs, in Bill C-74, the Budget Implementation Act. In our report, we made a unanimous observation stating, quote, "The committee is concerned that this type of significant change to the criminal code is encompassed in a large Budget Implementation Act," quote. Proceeding with remediation agreements this way, rather than in standalone legislation, forced our Senate committee to review this sizable issue in only 2 meetings. Further, we also made the unanimous observation that, quote, "The committee notes that it did not have the opportunity to hear the testimony of the Minister of Justice on the proposed amendments that are under her ministerial mandate, although she was invited to appear," quote. It is highly unusual for ministers not to appear before Senate committees during consideration of government legislation. In particular, the Senate Legal and Constitutional Affairs Committee has a reputation as a quality committee, and its deliberations have been quoted in numerous court decisions, including by the Supreme Court of Canada. On May 24, 2018, at our Legal Committee's first meeting on Bill C-74, departmental officials appeared without Minister Wilson-Raybould. We were informed that she was unavailable to attend and that she would be absent all week. As I noted to the committee during that meeting, I found that especially strange given that 2 hours earlier, I had watched Minister Wilson-Raybould giving a live interview from Ottawa on CTV's Your Morning Show. Later that same day, she fielded questions in question period and gave a speech on Bill C-75 in the House of Commons. Our committee was told that Minister Wilson-Raybould might be able to appear on May 30th instead. However, when that day arrived, our witnesses were Minister Carla Qualtrough, the Public Works Minister, and the Prime Minister's House of Commons seatmate, and the Parliamentary Secretary for Justice, MP Marco Mendicino. They appeared with Department of Justice officials. When Senator Boisvenu, the Conservative Vice Chair of the Legal Committee, asked why the Minister of Justice was not present, Minister Qualtrough said that Minister Wilson-Raybould was once again unavailable, but that she, quote, jumped at the chance to attend in her place, trying desperately to link the relevance of her public works portfolio to changes in the criminal code put forward in a finance bill. Meanwhile, MP Mendicino, who isn't even privy to cabinet discussions, jumped in a few times to answer questions. His unconvincing responses prove the point. If you don't have a seat at the cabinet table, you aren't equipped to answer for the Government of Canada at the Senate's Legal Affairs Committee table. Media reports that day indicated that the House of Commons Finance Committee had studied the remediation agreements portion of Bill C-74 for only 15 minutes. When I asked Minister Qualtrough which Trudeau minister had presented the remediation agreement portions of the bill at the House of Commons Committee, she couldn't answer the question. She had to consult Mr. Mendicino, who had to consult the justice officials, and they established that it had been Bill Morneau, the finance minister. Of course, recent events surrounding alleged pressure from the highest echelons of the Trudeau government on former Attorney General Wilson-Raybould regarding these remediation agreements now cast a whole new light on our entire committee proceedings. At the time, the Attorney General certainly didn't seem to want to touch the DPA portions of this bill with a 10-foot pole. Was she already resisting pressure from the PMO at that point? Meanwhile, the Senate, and our legal committee in particular, was under the gun to get this through at committee and report back to the Senate by May 31st. That timeline might also warrant further reflection. I find it rather rich that Senator Harder stood in this chamber last week and lectured opposition senators that they should have expressed outrage about remediation agreements in Bill C-74 when that legislation was in the Senate. We only had time for 2 meetings on this bill at Legal Committee because the Trudeau government insisted that committee reports on the matter had to be reported back to the Senate by May 31st. That's even more interesting, given that lobbying registry records indicate SNC Lavalin lobbied Government Senate Leader Peter Harder twice, on May 10th and May 31st. SNC Lavalin lobbied Senator Harder on justice and law enforcement concerns on May 10th. But what was the need for the meeting on May 31st? Was that meeting a champagne toast with SNC Lavalin to celebrate ramming through a major change to the criminal code without the Justice Minister even attending at our committee to defend it? Or was it to advise the committee on the plan to get that change passed through 3rd reading in the Senate chamber? I have many unanswered questions surrounding this whole affair, honourable senators, and I'm sure many of you do as well. That is why I ask you to vote in favour of Senator Smith's motion and vote against Senator Harder's amendment to help the Senate get to the bottom of this scandal for Canadians. New information is revealed daily about the political pressure allegedly exerted by the PMO on the Office of the Attorney General of Canada. Currently, Conservatives only hold about 1/3 of the Senate seats. Therefore, I appeal to my colleagues across the aisle. Honourable Senators, this is your opportunity to walk the talk on independence and demonstrate your commitment to the critical values of our rule of law and the independence of our criminal justice system. If this is not our duty as senators, then what is? That's why I ask you to support Senator Smith's motion. Canadians deserve answers. Thank you.